Mr. Bucol, your time's expired.
Thank you very much.
Thank you.
Counsel, a question before you respond to what you've heard.
Certainly.
Does your success in this case depend on this court's concluding that all mining use of the land is not banned? In other words, if we conclude, as your opposing counsel says, that everything is banned, this moratorium is equivalent to a ban, do you lose?
If it banned all mining and there was no way to
Extract the minerals.
extract the minerals in California, then I think I probably lose.
Well, I don't know
But-
about in California, but in this claim.
I don't think so.
Well, do you think there is?
Because-
Okay, go ahead.
Because, let's say the claim is in a place, let's say the claim is in Yosemite National Park or an equivalent state park. Or someplace
Yes,
that's
let's-
really
okay.
special. That's probably not possible, right? This is federal land. So,
Well, how about if we
in
just
some
talk about
special
this
place, why
land?
can't California say, look, we need to protect this resource, this river, these endangered species. You can't mine in this location.
All right, so that's your view. But actually, you don't take the view that this ban deprives Mr. Rinehart of all his interest in the mining claim, do you?
No, no. He can mine on the land. He can mine with non-motorized methods, and he can wait till the moratorium ends.
But the economic viability is not important.
Correct. Correct. Did I answer your
You
question?
did, thank you very
Okay.
much.
A couple minor things, and then I want to talk about something. First of all, Mr. Bucol started off by saying that 30 USC 22 had to do with these local minor regulations. But that is not the meaning of the statute, because the statute says, under regulations prescribed by law and according to the local customs or rules of miners in the several mining districts. So those are two separate things. So I think we go back to what we talked about before, which is that under regulations prescribed by law includes state laws. Secondly, there's been some discussion about the United States' amicus brief, and I think the United States Department of Justice does not have briefs filed unless they go through the appropriate channels. And we were told that the Solicitor General's office approved.
And is
file-
that in the record anywhere?
No, of course not. No. But they don't file briefs unless they're approved. And I assume this went up as far as it
And
needed
that's
to
in the
go.
record somewhere?
Hmm?
That's in the record somewhere?
Well, they filed the brief.
Well, I assume that
That's
if
in
we,
the record.
Yeah, right.
I assume if we get a brief from the United States Attorney General, we take it at face value and we don't go through hierarchies or personalities or junior attorneys or senior attorneys. It's a brief for our
Right.
purposes.
Right, exactly. Mr. Bucol likes to talk about all these cases that he says that struck down bans of mining. The cases are universally in recent history, but before Granite Rock, except for South Dakota versus Lawrence County. All the other cases he cites were before Granite Rock. And I think it's important to realize what Granite Rock ruled. So in the Ninth Circuit, the court in Granite Rock, the Ninth Circuit ruled that the county cannot prohibit the use, either temporarily or permanently, in an attempt judgment for that Congress. and this view. Justice Powell said, "The court's opinion today approves a system of twofold authority with respect to environmental matters. The result of this is that state regulators, whose views on environmental and mineral policy may conflict with the views of the Forest Service, have the power, with respect to federal lands, to forbid activity expressly authorized by the Forest Service. I dissent." And the majority addressed this point. And they said, in their conclusion, that they did that principle. Submit that Granite Rock stands for the proposition that can balance these interests differently than the federal government, even on federal land. And that's what the legislature has done. And they haven't done anything unreasonable here. They have asked for a study, and they have said that we want full mitigation of all significant environmental effects. Not all effects, significant environmental effects. And as this court knows, under CEQA, significant environmental effects are judged against a threshold of significance. And the thresholds that were not de minimis. As to fish, the effect had to be on a population level. As to mercury, there had to be a significant adverse effect on a beneficial use. Those thresholds of significance are in the record. We asked the court to take judicial notice on those documents. These are not de minimis effects. I understand that Mr. Buchel disagrees with that assessment. He can have a different position.
Well, he
But
can have a
he's
different
not the one
position,
who
and
gets-
he says they're not significant, and you can have a different position, and you say they are significant. Counsel, I suggest that doesn't advance the ball one iota. All we're hearing is your opinion and his opinion.
No, but
So if you could ground your argument in something more substantive, it might be helpful.
And then you may answer the question, but your time's expired.
it's not my opinion that matters. It's what the agency and the legislature decided. And the legislature decided we want full mitigation. And this agency, after doing an EIR over 2 years, costing $2 million, that is over 1,000 pages, came to these conclusions. Mr. Buchel has challenged those. Those will be litigated. But those judgments are entitled to respect. And if we go down a road of saying that reasonable environmental regulation is all that's allowed, then we start to second guess the agency's decisions. And those agencies were empowered by the legislature.
Thank you, Mr. Melnick.
Thank
Thank you,
you.
counsel. The matter's submitted.